For those of you who don't know me, my name is Leonard Leo. I serve as co-chairman of the board of the Federalist Society, and it's great to see all of you here today. I know many of people who are here, some I don't. It's especially heartening to see so many people from around the world here today. Before we move to the substance of today's very good panel, there is one piece of business I'd like to take care of, which is very important. You know, there are times when an individual undertakes a project that ends up being truly transformational and impactful. And the man I want to talk about today who's done that is Jim Kelly, who has been for almost 20 years, I think, Director of International Affairs for the Federalist Society. Jim was a real visionary because, 20 years ago or so, some of the problems that we see with global governance and internationalism were kind of rearing their heads, but it wasn't reaching the front pages of newspapers or on the news on a regular basis, at least the way it is today. But I think Jim saw the writing on the wall, and he knew that it was really important that the Federalist Society be a vanguard for the defense of sovereignty, and took that to heart in ways that would, operationalize our beliefs. And that's what he's done for 20 years. He's been a prolific writer and thought leader about global governance and sovereignty, international law, but also operationally, he's built something that is really important and really enduring. I don't know of another network of international lawyers and jurists in particular that is more, frankly, distinguished and potentially impactful across the board than the people that he's identified and cultivated. And so my purpose today is really just to offer a tremendous debt of gratitude on behalf of the Federalist Society for Jim's many years of service building the international division and really, I think, changing the terms of debate about global governance and the creeping presence of international law. And so to thank him for those many years of service and to congratulate him for what he's built, because it is an extraordinary network of people. Many of you are here. And I know so much good will come of this in the coming years. So Jim, if you would please come up. We have a little token of appreciation. This is just a book with a lot of great memories. Wow. Of projects that you've undertaken, people that you got to know, and I think it's a really nice sort of way of thinking back on the many years of service to the organization and the incredible relationships and friendships that you forged. Thank you for everything, Jim.
Thank you, Leonard.
Thank you very much.
Wow, just when Lisa was making me give hundreds of books away to clear our house, I get another one, and probably the most important one. So thank you. That's very kind of you, and I look forward to recalling those memories and keeping that in a prominent place. Thank you very much, Leonard. Leonard's such a great speaker without notes. However, that's not the case, so I'm going to stick to my knitting, and I want to thank Leonard very much. I would like to express my deep appreciation to Leonard and Frank Hanna, who were responsible for supporting the Federalist Society's launch of the International Project in 2006. During our introductory breakfast at the Mayflower Hotel, Leonard suggested that I serve as Director of International Affairs on an of-council basis. He suggested that I use the following 2 years to assess the international law and policy landscape and nascent global governance movement and report back to him. In mid-2007, I sent Leonard my early assessment, but was uncertain about the impression it would make. In my memorandum, I explained to Leonard that the United Nations was working with a matrix of human rights governance networks to promote global governance, indoctrinate children through compulsory international human rights education, establish a Church of the United Nations, interfere with democratic evolution at the national level, and community organize for the building of a global welfare state. In response, I expected Leonard to think one of two things. Either, this guy's a genius, let's get him outside of the United States and get him the help he needs. Or, this guy's crazy, let's get him out of the United States and get him the help he needs. Whatever the case, Leonard told me to pack my bags and assigned Alyssa Reyna from his office to serve as my first Deputy Director of International Affairs. Thanks to Alyssa for her important service early on and for rejoining our efforts in 2023. Thank you to the other bright, dedicated young deputies with whom I worked for the past 20 years, Ken Wiltberger, Paul Zimmerman, Kate Pesci, and Jose Nunez. Also a special thank you to Steve Calabresi, who has been a reliable cheerleader for our work, providing encouragement and support to me at key junctures in our efforts. Thank you to Dean Reuter for being an early supporter of and resource for our law and liberty outreach. Thanks to Judges Britt Grant and Lisa Branch of the U.S. Court of Appeals for the 11th Circuit. For the past 5 years, they have taken time from their busy schedules to participate in our transatlantic judicial exchanges with judges from the European Court of Human Rights and European constitutional courts. Most of all, I thank my wife, Lisa, who has encouraged and advised me in my work for the entire 41 years of our marriage. Almost 17 years ago, on November 18, 2007, I responded to a French attorney's questions, and he's here today, Francois-Henri Briard and his associate Paul Mesquer. They were questioning what would be the development of the Federalist Society in Europe. The following is our word-for-word exchange. Their question: what are the perspectives of evolution of the Federalist Society in Europe? I responded: to establish creative minorities within the European legal community who support and promote liberty, the rule of law, the independence of the judiciary, and limited government. They asked, what is the profile of the target? I replied that the target audience consisted of accomplished attorneys and judges who believe in our mission, and energetic young lawyers and law students who are willing to devote about 12 hours per month to the Federalist Society. They asked, what are their needs? In reply, I wrote, they believe that overall, America is a positive influence in the world. They want to learn more about the Federalist Society's mission. They want to build solidarity with other compatible legal professionals in their communities. They are interested in monitoring a particular area of law to enhance their expertise, and they want to establish a platform in the U.S. for their professional development. Well, I can proudly say mission accomplished and exceeded. Presently, through the inspiration and support of the Federalist Society, there are lawyer and law student groups from 20 nations participating in the International Law and Liberty Society. I attribute this huge success to three main factors. First, it occurred through prayer, the grace of God, and the power of the Holy Spirit. Second, it occurred because of the interest and work of committed lawyers and law students throughout the world who collectively have the following attributes that are essential for establishing a creative minority in their countries: awareness, resistance, passion, courage, energy, entrepreneurship, diligence, selflessness, maturity, patience, sacrifice, and perseverance. Third, these results occurred because of the Federalist Society's respect for the principles of solidarity and subsidiarity. Leonard Leo had faith that young lawyers and law students from around the world would rally around the Federalist Society's motto and principles. I had faith that they would do so by organizing independent law and liberty circles in their respective nations. The International Law and Liberty Society is a historic textbook example of the power of creative minorities, solidarity, and subsidiarity. In the years ahead, I look forward to participating with you in writing the next chapters in that book. Thank you very much. So this is the inaugural panel discussion dedicated to the international participants that we have in our Law and Liberty circles. And so if you would please, I will introduce the panelists, and they can come and take their places reserved for them. The Honorable Judge Britt Grant, my dear friend from Atlanta, Georgia, in the 11th Circuit U.S. Court of Appeals. Thibault Mercier, the chairman of the France Paris Law and Liberty Circle. He's also president of the International Law and Liberty Society. I see next Aylana Meisel, who is the president of the Israel Law and Liberty Forum, and who hasn't been through much the last year and a half. But in spite of all that, they have maintained their presence, and they're making a decisive impact on the state of the legal culture in Israel. And finally, my colleague and dedicated mine, right? Jose Nunez, who is president of the Law and Liberty Society in Brazil, which has chapters in Sao Paulo and Brasilia. And he also works as the executive director of the International Law and Liberty Society. And with that, I'll turn it over to you, Judge Grant. Thank you so much.
Thank you, Jim. I really appreciate it. First, I would like to take a moment of personal privilege to echo Leonard's kind words about Jim and his praise for the groundbreaking work that Jim has done in spreading the Federalist Society's commitment to the rule of law and the principles of the Constitution and Declaration of Independence. It has been my privilege to work with Jim and to participate in judicial exchanges and other activities in various countries, including giving a speech in London in the shadow of a very large portrait of King George. I was pleased to remind him that we had won. Jim's difference, as I say, has made a great difference to me personally, as I've had the opportunity to think about and talk about America's constitutional heritage with friends and colleagues overseas, and his work, he has done meaningful and important work around the globe. So thank you, Jim. The title of today's panel is National Sovereignty and Global Governance, Emerging Fault Lines in International Law. Are international authorities, in the name of global governance, encroaching on national sovereignty? 3 recent international cases highlight that tension. The International Criminal Court's arrest warrants for Israeli leaders Benjamin Netanyahu and Yoav Gallant, the advisory opinion by the International Court of Justice declaring climate change an existential threat in the name of international law, and the signing of a Memorandum of Understanding between the United States Development Program and Open Government Partnership in 2019 to advance what's called Sustainable Development Goals. Indeed, the list could go on. Some view these cases as necessary for international accountability, while others argue that they undermine states' democratic authority. Our panel will explore those looming questions, as well as talk about some of the work that the Federalist Society and Law and Liberty circles are doing to support the rule of law and accountable democratic governance. So we've introduced our panelists already. Thank you, Jim. First, each one of them will briefly discuss the efforts that they're doing in country related to law and liberty and the Federalist Society. And then after that, we'll have another round of discussions related to the specific topic at hand. So Thibault Mercier, let's start with you, please.
Thank you, Judge Grant. 200 years ago, it was Tocqueville who crossed the Atlantic to discuss with the... 200 years ago, it was Tocqueville who crossed the Atlantic to discuss with the Americans, and today, I'm sorry, but I fear that you've lost in the exchange. But I will do my best to make up for the downgrade. In any case, I'm really, truly honored to be here today in Washington, and thankful to the Federalist Society, to Jim, for this invitation. A few words on the French Cercle Droit et Liberté, the French Law and Liberty Circle. You know, in France too, we see the same tendencies that you often denounce here. Judges who tend to interpret the law the way they want it to be rather than the way it is. Free speech under growing pressure in the media and at the university. And law professors who claim to be neutral while their teaching often hides a strong political bias. This is why we created the French Cercle Droit et Liberté 11 years ago, inspired, of course, by the model of the Federalist Society. Today we have around 2,000 members, which for a country 5 times smaller than the US would be the equivalent of 10,000 on your scale. We operate independently from the Federalist Society, even of course, if we share very similar principles. Unlike the FedSoc, we do sometimes take public positions, and even sometimes we litigate, a bit like what Judicial Watch does here in the US. But in a nutshell, our circle organizes debates, publishes analyses, occupy the media and the courts, and bring together lawyers and students from all over France, Europe, and now world.
Thank you. Next to Aylana.
All right. Well, it's an honor to be here, and I too echo the thanks to the Federalist Society for giving a platform to this discussion, and to Jim for really his tireless efforts for so many years. More into the microphone. All right, fine. I'm a little self-conscious because I think I'm the only one without like a really nice exotic accent on the panel. So if you want, I can talk like Israeli, but we'll forgo it. Okay, so the Israel Law and Liberty Forum addresses an existential challenge to the state of Israel that's often overlooked because of our pastime of fighting enemies on every border and beyond. And that is that we are in constitutional disarray. We didn't have a founding like the states. We didn't inherit a system of government that evolved over a long period of time. And so we have these escalating constitutional crises now, building for several decades. And you can probably pin it on a whole series of different issues: the lack of a constitution, the transformation of Israel's judiciary into the most powerful judiciary in the entire world, a militarized academy that actively promotes juristocracy, and a number of others. But our mission is to try to address those issues by cultivating a new generation of legal leaders and bringing this tradition of classical liberal and conservative principles of law and governance to enrich Israel's discourse on law and democracy. So over the past 6 years at this point, we too have, even more so I think, shamelessly ripped off the Federalist Society model. We've established chapters at 4 of 5 leading law faculties in Israel. We cultivate young and more senior lawyer circles. We publish a law journal that we thankfully have had many contributors to, including professors and attorneys and judges and Supreme Court justices, and it too has been cited by the court. And I am hopeful that our digital resources, our debates and events and clips and so on, will, over the next year, break 1 million views. So in addition to that, I'll just say that I think American attorneys have a very vital role to play in helping our work. And it's in the ideas that they can share and the professional collaborations that they can build, and maybe even what they can learn from the... I'm sorry. There's a lot of pots and pans behind me. So what they can learn from the complexities that Israel is facing, whether it's on constitutional questions, international law questions, or how to think about innovative new technologies. So I look forward to this discussion and to whoever's interested in becoming more involved in what we do or learning more, speaking after the event.
Thank you. Jose.
First and foremost, I'd like to thank you, Judge Grant, for the introduction and for the opportunity to be part of this distinguished group of panelists. We're going to be addressing the impact of global governance on national sovereignty. I'd like to thank once again Jim for your tireless work, for your kind words and encouragement. So I'm the president of the Brazil Law and Liberty Society, and I also serve as the executive director of the International Law and Liberty Society. The Brazil Law and Liberty Society is dedicated to upholding the principles of constitutional government, subsidiarity, and individual rights. We are very proud to be part of the international network of the International Law and Liberty Society, inspired by the successful model of the Federalist Society. I'm here today with my dear colleague and friend, Andrea Hoffman, who is representing our board as well. So we have circles, law and liberty circles in Brasilia and São Paulo. And I believe that the issues that Brazil faces today is similar to many of the issues that you face both here in America and my colleagues and friends in their own countries. What the French call the gouvernement de juge, juristocracy, lawfare, the weaponization of the judiciary and administrative agencies in order to undermine democratic evolution and the principle of subsidiarity, the erosion of fundamental freedoms and rights such as property rights and freedom of speech, and the near hegemonic role that soft law norms generated by the United Nations and the Inter-American system play in how domestic law is interpreted and enforced. So this year we organized, our last event was organized with Professor Paulo Carosa from the University of Notre Dame, in which he addressed the importance of freedom of speech for the fulfillment of human rights. And we see ourselves as encouraging the formation of creative minorities, right? We want to work with lawyers who have a spirit of service and sacrifice and are willing to have an impact on the legal culture of our country. And our goal is that in the next 20 years, Brazil Law and Liberty Society will have a transformative role in the Brazilian legal landscape, just like the Federalist Society had and is having here in the United States. And I look forward to joining you today and discussing these ideas with my dear colleagues and friends. Thank you very much.
Thank you. That's great to hear about all that you're doing in your countries. Now let's hear about perhaps a darker end of things. We'll start with Thibault.
Thank you, Judge Grant. I will speak today of the recent advisory opinion of the International Court of Justice. Opinion that declared climate change an existential threat. And last July, we could read all over the news that this opinion was the opening of a new era for climate justice. Well, let me already be clear on what I think of this decision. In my view, this is not a legal decision, this is a political decision, and I will tell you why. On July the 23rd of this year, the ICJ unanimously held that, I quote, states have binding obligation to protect the climate system and the environment from human-made greenhouse gas emissions. The court went further. If a state fails to meet this obligation, that may constitute an internationally wrongful act engaging state responsibility. The court gave a few examples of such failure, such as granting new fossil fuel licenses or neglecting to regulate emissions. In such cases, states would owe cessation, guarantees of non-repetition, and reparation. The court also affirmed a right to a clean, healthy, and sustainable environment. And by doing so, it linked climate obligation to human rights. Let me propose a few comments on this decision. First, who here knows what the ICJ is? We tend to get lost between all of these acronyms, ICC, ICJ, ECHR, and most people, even lawyers, have never heard of the ICJ. And very few could even name a single one of its judges. And to me that says something very important. A court that rules for the whole world but is unknown to the very citizen has serious legitimacy problem. So for those who don't know, the ICJ is the principal judicial organ of the United Nations, and it is based in The Hague in the Netherlands. Its role is to settle disputes between states and also to give advisory opinions on questions of international law. These opinions are non-binding. Yes, formally, this ICJ opinion that we're discussing today is non-binding. But in practice, it is already being used as a moral and legal reference point in courts, treaties, and diplomatic negotiations. Even the ICJ's website says such opinions carry, I quote, great legal weight and moral authority. And I believe that they are right, because often in practice, non-binding norms become law in practice. Judges, NGOs, bureaucracies cite them to pressure governments, and we've seen it before, soft law becomes hard politics. So the real issue here is not whether it is binding or not, but how it slowly infiltrates national systems and challenges sovereignty. I know each decision may seem small, but together they shift the center of gravity away from national democracies toward international bureaucracies. And the ICJ opinion adds another layer to this. And I will give you a specific example in this respect, a 24 European Court of Human Rights decision. Klima Seniorinen versus Switzerland. In this decision, the European Court of Human Rights ruled for the first time that climate inaction can violate human rights. In this case, there was a group of elderly Swiss women that had claimed that Switzerland's weak climate policy endangered their health and violated their right to private and family life. It's the Article 8 of the Convention. And the ECHR agreed. It found that Switzerland had failed to set and implement adequate climate targets consistent with its international commitments. The courts also state that states have a positive obligation to protect citizens from serious adverse effects of climate change. We can think what we want of this decision, but let me remember something here. Switzerland accounts for 0.1% of global greenhouse gas emissions. We could wipe out tomorrow Switzerland off the map, and the global temperature would not change at all. Well, I hope there's no Swiss citizen here. To me, this shows how symbolic and moral this case is hard. So what I am trying to show here as well is that we have committees and courts claiming the moral authority to reshape national laws in the name of great and vague principles: humanity, climate justice, sustainability. And in this opinion, judges even validated the 1.5-degree threshold as if it were a legal rule. And they also declared that states are legally responsible not just for their own emissions, but for their contribution to global harm. How can these judges know and be sure of such contribution? I thought that the causal link between, on one hand, national emission, and on the other hand, global harm, was still scientifically uncertain and politically contested. Are these judges scientists? Do they have the competence to decide scientific truth? I think not. I think the role of a judge is not to decide the truth, but to apply the law. Climate change, its causes, and its remedies should remain subject of open debate. Another comment I would have: who are these judges? Does anyone here know President Iwasawa, Vice President Sebutinde, Judges Tomka, Abraham, Yusuf, Gzu, Bendari? You know, the ICJ is presented as a judicial body, but in practice, its selection process is very highly political. And this makes this court less of a purely neutral court of law and more a reflection of global diplomatic power. One last comment before I conclude. To me, there is a deeper problem here, maybe the most important, When the ICJ calls climate change an existential threat, it moves beyond science and law to go into eschatology. Climate discourse has become a kind of secular religion. It has its dogma, men and women. Sorry, ladies, you are into. Men and women are responsible for climate change. It has its original sin, capitalism, industrialization. It has its prophets, IPCC, NGOs. It now has its inquisitors, international judges of the ICJ. And it even has its heretics, those who doubt. This is questionable, but this is very efficient, because by turning climate into a sacred cause, these institutions gain moral power to override national choices in the name of a higher good. But we should recall that science and law must not be preached, they must be applied. Now, how do we respond? It's easy to criticize, it's harder to propose, but let me suggest 3 ways forward. First, raising awareness. Most people have no idea how advisory opinion works and how NGO litigation shape domestic law. Our duty as scholars, lawyers, citizens is to bring this mechanism to light. And this is, I think, what we are doing here today. 2, we should recognize that these decisions are not legal, but are politics. What these courts produce is not law, it's political power disguised as law. The response is not just legal, it's also political, and states must build the economic and geopolitical strength to resist ideological pressure. And I think that's what President Trump did when he withdrew the US from the Paris Agreement earlier this year. And 3, and last, we should engage and don't retreat. The progressives, they have mastered what I call institutional entryism. They occupy international organizations, panels, NGOs, whereas we have conservatives that often prefer the private sectors, and they ignore these arenas. We must realize that these institutions are political battlefields. If we abandon them, we will lose the narrative, and their law, will follow that narrative. So we need to send competent jurists and diplomats into these bodies, and not just complain about them from afar. Merci beaucoup for your attention, and thanks for being so patient with my accent.
Thank you. That was very interesting. Jose, I believe that you're next.
Well, thank you very much. My talk is going to be divided into 4 parts, namely, 1, explaining the collaboration between the United Nations Development Programme, the UNDP, and the Open Government Partnership, OGP, to promote the Agenda 2030, also known as the 17 Sustainable Development Goals, or the SDGs. Second, I'm going to highlight the role that a matrix of human rights governance networks plays in leveraging the work of UNDP and OGP. Third, I'm going to highlight how national and subnational initiatives inspired by the matrix are impacting the domestic laws of sovereign countries. Fourth and last, I'm going to explain how these initiatives undermine national sovereignty, the democratic process, and the principle of subsidiarity. So, in February of 2019, the United Nations Development Programme and the OGP entered into a Memorandum of Understanding. Under the terms of the MOU, they committed to collaborate with each other to promote open government initiatives as tools to implement the SDGs, especially SDG number 5, gender equality, and SDG number 16, peace, justice, and strong institutions. And this commitment was renewed in October of this year through a new Memorandum of Understanding. So the UN General Assembly created UNDP back in November of 1965. It is the leading UN agency on international development, whose mission is to provide countries with capacity building to implement policies aimed at promoting sustainable development. The headquarters of UNDP are in New York City, and their operations are overseen by a 36-member executive board representing UN member states. Meanwhile, UNDP's partner, the OGP, is a multilateral initiative established in 2011 on the sidelines of the UN General Assembly under the leadership of 8 countries, including Brazil, the US, and United Kingdom. According to the OGP declaration, the countries commit to implementing reforms to make governments more open, transparent, and participatory. From 2011 to 2025, the OGP network grew into 76 national governments and 152 subnational governments that co-create national action plans in cooperation with civil society organizations. These national action plans, they are drafted and then they are implemented in cooperation between governments and civil society and assessed on a 2-year cycle basis. Meanwhile, through an independent reporting mechanism, the OGP Secretariat monitors the National Action Plan implementation and holds OGP members accountable for their commitments. President Barack Obama considered OGP one of his administration's signature initiatives. As a result, the U.S. administration established in 2011 a Center for Excellence on Democracy, Human Rights, and Governance, financed by the United States Agency for International Development, the USAID. The USAID Center was designed to facilitate the integration of developing countries into the OGP network and to administer a portfolio of contracts, grants, and funds to leverage and facilitate the work of OGP across the globe. According to the OGP website, from 2014 to 2025, the USAID contributed nearly $7 million to OGP in order to further its mission. Meanwhile, George Soros's Open Society Foundations announced that they were awarding a challenge grant to OGP worth of a potential $10 million in new support. The matching grant was designed to, quote, help OGP scale up its work and support its members in government and civil society to co-create and implement open government reforms that deliver results for citizens. Likewise, in October of 2022, the Ford Foundation awarded a $4.3 million grant into OGP to, quote, promote transparency, empower citizens, and harness new technologies to strengthen governance and core support for institutional strengthening. This cooperation between OGP and UNDP, private foundations, and development agencies to advance the SDGs and open government reforms evidences the existence of a matrix of human rights governance networks. The matrix is an intelligent, complex, adaptive system comprised of 10 subnetworks, which transnational progressives use to advocate, interpret, monitor, enforce, and fund policies aimed at governing economic, political, and social affairs worldwide. Let me give you an example of how the matrix operates in my own country, Brazil, which was one of the founding members of OGP. So the federal government of Brazil established in 2014 an OGP civil society working group. This working group has a 4-year mandate and works in conjunction with the federal government to create, implement, and assess Brazil's National Action Plan. The OGP working group members include civil society organizations, trade unions, and academic institutions that both receive and distribute grants from development agencies and private foundations on a recurrent basis. For instance, from 2020 to 2025, Open Knowledge Brazil received nearly $600,000 in grants from the Open Society Foundations, the Ford Foundation, the U.S. Consulate in Brazil, and USAID. From 2023 to 2024, INESEC received nearly $600,000 in grants from the Open Society Foundation, the Ford Foundation, and the European Union. And in 2023, Imaflora received a grant of 1.6 million euros from the European Union. As an attempt to end this corporatist takeover of the federal government, the conservative Bolsonaro administration in Brazil adopted a decree in 2019 that terminated a series of government civil society partnerships, including the OGP working group. However, under the current socialist Lula government, OGP Brazil is back in business with a new national action plan committed to establishing, quote, a collaborative network for training territorial agents to boost social participation through popular, digital, and media education, promoting healthy and sustainable territories. So OGP in Brazil and around the world moves forward, with the matrix benefiting from a framework that allows them to have access to government data, discretionary budgets, and staff members in order to reshape global ethical, regulatory, and governance standards. In OGP nations, transnational progressives aligned with the administrative state and compliant judges are able to bypass the executive and legislative branches, thus interfering with organic democratic evolution and the principle of subsidiarity. And to make matters even worse, in 2016, OGP launched OGP Local, which also allowed subnational governments to join the OGP network and endorse the OGP declaration. Just like with national governments, subnational governments can now elaborate their own action plans. Currently, there are 6 cities in Brazil that are part of OGP Local, including the city of São Paulo, which is the biggest city in the country with nearly 12 million people. So this does raise the question, is it possible to stop or at least curb the influence of the matrix, UNDP, and OGP? Well, there are now new hurdles that the matrix is trying to overcome. One hope is, for instance, the reduction in development aid for such projects. According to the OECD, official development assistance from wealthier nations who fund these projects is projected to drop between 9 and 70% this year. Last year, official development assistance dropped 9%, with significant cuts being led by the United States, the UK, France, and Germany. These cuts are reshaping international finance, which is leading OGP and UNDP to look for other sources of funding. Moreover, transnational progressives and the matrix are facing strong headwinds from the rise of populist leaders across the globe, who are trying to reclaim national sovereignty and redirect their efforts from global governance to national priorities. Finally, as part of the current U.S. administration's effort to downsize the federal bureaucracy, the Open Government Federal Advisory Committee was terminated in February of 2025. But as they say, the empire strikes back. At the October 2026 OGP Summit, which took place in Vitoria-Gasteiz in Spain, delegates participated in a workshop titled Rethinking Democracy Support. The workshop attendees included all of the usual suspects, including the Deputy Secretary General of the OECD and representatives from the Ford Foundation, the World Bank, and UNESCO. The scope of the workshop was to, quote, bring together ministries of foreign affairs, funders, and partners in the area of democracy support to explore how to better align foreign policy strategies with development instruments in an area marked by shifting geopolitical dynamics and increasing pressure on aid budgets. Clearly, the participants of the matrix are on the move to secure alternative sources of funding for their operations. Meanwhile, closer to home, there are 2 U.S. cities that are part of OGP Local, the city of Austin, Texas, and New York City. The city of Austin has been a member of OGP Local since its establishment in 2016. Its current action plan, 2024-2028 was developed in collaboration with community-based organizations, academic institutions, city staff, and OGP, and has commitments centered on 3 areas, namely climate change, economic resilience, and AI accountability. In January of this year, the New York City officially endorsed the OGP declaration, thus becoming part of OGP Local. Although the city does not have an action plan yet, the co-creation process is already underway. One can only imagine what New York City's action plan might look like now with the election of the self-proclaimed socialist mayor Zoran Mandani, or any other local or regional government in the world that elects a progressive candidate who wishes to promote the work of the Matrix through the OGP action plan. As the Hudson Institute scholar John Fonte warned in his book Sovereignty or Submission, the rise of transnational progressivism has become a critical issue in our age. As the America 2050 approaches, it would be encouraging to see Americans rejecting transnational progressivism and sticking to what represents one of the most incredible weapons against the Matrix, the Declaration of Independence and the U.S. Constitution. Thank you very much.
Thank you, Jose. Now we'll hear from Aylana.
Thank you. So I'm going to talk today about what my friend Professor Eugene Kantorovich calls the story of a court with no jurisdiction, investigating crimes in a state that doesn't exist, crimes that never happened. And he's relating to the warrants issued for Prime Minister of Israel, Benjamin Netanyahu, and former Minister of Defense, Yoav Gallant. And so the question is, how do you get to that position? We're going to focus really on the first 2 points: the court with no jurisdiction, investigating crimes in a state that doesn't exist, because those are really the most relevant to other countries, and specifically to the United States as well, where the ICC had previously set its sights on American servicemen and members of intelligence, and could well do so for more senior political officials in the future. So I'm going to start by explaining the International Criminal Court as an institution, and then including the U.S. and Israeli suspicions about it from the get-go. And from there, we'll talk about a 15-year coordinated campaign to create a fictional state of Palestine over which the ICC could assert jurisdiction and thereby continually harass, investigate, and try to isolate Israel on the world stage. But again, the lesson here is global. So the ICC was created by the Rome Statutes, international treaty. ICC is tasked with exercising jurisdiction over the most serious crimes of international concern: genocide, war crimes, crimes against humanity, and the more recently added crime of aggression. The supranational court seemed to have safeguards for state sovereignty, and those included voluntary membership, a prohibition on investigating crimes prior to its establishment, and an inability to try individuals in absentia. But primarily, there's the principle of complementarity, meaning that the court intervenes only if a sovereign state is unwilling or unable to prosecute crimes on its own. An ICC investigation, which is a mechanism that leads to trial, can be triggered by a referral from a member state, from the UN Security Council, or when the alleged perpetrator is a national of a member state, or when the crime was committed in the territory of a state party that accepts jurisdiction. You might be hearing the word state repeatedly. If a defendant is convicted, he can be apprehended in any member state and jailed. So numerous countries participate in the drafting of the Rome Statute, including Israel and the United States, but they ultimately refuse to ratify it because of sovereignty concerns in the case of the U.S., which the year that the court is established even passes specific legislation that limits cooperation with the ICC and is meant to protect American servicemen, officials, and the officials of certain allied countries from prosecution by an international court of which the U.S. is not a member. Now, the State of Israel was a proponent of the court for a couple of reasons. One is that the quest for justice against heinous war crimes has particular historical resonance for the Jewish people. But the other, maybe less lofty reason is that there's actually nothing that triggers greater visions of sugar plums dancing in the head of Israel's legal elite than the idea that there's a supremely powerful judicial institution that you can argue before to check the demons of human nature. The enchantment sours when a clause is inserted into the Rome Statute that specifically targets, almost quite clearly targets, Israeli settlement in Judea and Samaria, and after failing to have the clause removed, Israel does not sign. Okay, so we're now almost 24 years after the establishment of the ICC, and it's basically become a monument to sluggishness, to budget bloat, to corruption. It maintains 900 staff members and operates on a budget of nearly 200 million euro annually. It's finalized only 33 cases in its entire history, and some of those were because the defendant died. Cases have dealt disproportionately with African countries, and some of the African members are now leaving the court, and there have been certain warrants, like that issued for Vladimir Putin, that have simply been laughed off. It's also been criticized for judicial and prosecutorial misconduct, including sexual misconduct by the current prosecutor. So a shrewd observer might look at all this and say that you have an institution in disrepair that's looking for a win. And that brings us back to the headline: a court with no jurisdiction investigating crimes in a state that doesn't exist, crimes that never happened. There are two major blows against sovereignty in this story. One is against Israel, clearly, but one is against the very definition of a state, and therefore our shared understanding in the West of sovereignty and the liberty of nations to self-determine. So in the interests of time, I'm going to focus the story on actions taken by the Palestinian Authority, the UN, and the ICC since 2009, which is when the PA first attempted to deploy the ICC against Israel. And I'm going to leave out an important element, which I think that my co-panelists addressed in their own talks, which is the role of the supposed human rights organizations, primarily in this case funded by European capitals and foreign foundations, but I imagine that that's somewhat common to us all. And what happens is that they often, through their activism, generate false or decontextualized reports that are cited uncritically in international fora, and their main purpose is to entrench the idea of Palestinian statehood while also weaving a narrative of Israeli human rights abuses that justify international isolation, okay? So that's a different talk. We're going to focus just on this question of the ICC and the PA. Starting in 2009, the Palestinian Authority tries to get the ICC to investigate alleged Israeli crimes in what they claim is Palestinian territory. And the first attempt is rejected because the purported Palestinian state has neither a defined territory nor sovereignty. In fact, the alleged state of Palestine includes Gaza, which at the time is governed by Hamas, which is one of the few jihadist groups that could sanitize a terror-funding regime like the PA by comparison. In 2011, Palestinian President Mahmoud Abbas, who I think is soon approaching his 21st year in office?
21st year in a 4-year term.
I was going to say undemocratically elected, okay, explains in the pages of the New York Times that the Palestinian aim in holding itself out as a state is to join the ICC and other international organizations in order to internationalize the conflict as a legal matter. So, not human rights, not peace, but the internationalization of a political conflict. And they succeed. In 2012, the PA successfully lobbies the UN to change its status to non-member observer state. And then the name is changed to the State of Palestine. The UN's legal council decides in an internal memo that Palestine is a state that's entitled to ratify treaties, including the Rome Statute. And there goes all that nasty business about sovereignty and statehood. So what's a state? Whatever the UN General Secretariat says is a state. Why Palestine and why not Kurdistan? Why Palestine and why not the Islamic State? Okay? So in 2015, the purported state of Palestine accedes to the Rome Statute and requests that the ICC backdate its jurisdiction over Israeli crimes in allegedly Palestinian territory to 2014, which it does, and then the court also takes jurisdiction over crimes committed by Palestinian nationals in Israeli territory, although it doesn't do very much with that over the years. The ICC prosecutor at the time opens a preliminary investigation to determine if the statutory criteria for initiating a full investigation into Palestine are satisfied. And during this period of preliminary investigation, the prosecutor was required by the Rome Statute to report on its status every year. So we know that from 2015 to 2020, the prosecutor refused to look into numerous very serious criminal accusations against Palestinian defendants, including terrorist murder, torture of dissidents, targeting of Israeli civilians with military force. Instead, the prosecutor tried to create grounds for prosecuting Israelis. And press releases made clear that the process was being carried out in full cooperation with and under the guidance of the PLO and its strategy for internationalizing the conflict with Israel or against Israel as a legal matter. In 2018, the purported state of Palestine asks the ICC to open effectively an endless witch hunt, investigating all past, current, and future crimes in its territory. And in 2019, the ICC prosecutor seeks a determination of the territorial bounds of jurisdiction. They're still trying to figure out where they can apply jurisdiction in the investigation that they've decided to basically open. So the prosecutor's position from the outset is they're unsure of whether there's a Palestinian state, but it doesn't really matter because procedurally there is enough of a state that's been recognized enough to invoke jurisdiction. And that position was really ultimately accepted by a panel of the court, meaning that the ICC has basically used this case to establish its complete disregard for state sovereignty. Within a month of the court deciding that it had jurisdiction, the prosecutor declared that she had opened an investigation into the situation in Palestine. Israel challenged that jurisdictional determination, and its challenge was dismissed. The ICC's involvement in the Gaza war is, according to the ICC, an outgrowth of this investigation opened in 21, although Israel disputes that this should be the case. And of course, toward the end of 24, the result is the issuance of the warrants for Prime Minister Netanyahu and former Defense Minister Gallant for alleged war crimes and the crime of starvation. There are warrants issued, or announced at least, for 3 Hamas leaders and eventually issued for, I believe, 1. At the time that the warrants were issued, the Hamas leaders were all dead, so that was dealt with effectively. And Israel, of course, has challenged the warrants for the lack of jurisdiction and on the basis of complementarity. Just a couple of weeks ago, the ICC rejected Israel's appeal to withdraw the arrest warrants on the grounds the jurisdictional question is once again pending. And it's pending because, it's not dismissed anymore, it's pending because it turns out that when a decision is political pressure does potentially change it. And there's duress now from sanctions imposed by the Trump White House on ICC personnel. Somebody just cheered. And so the appeals chamber in the ICC reversed the dismissal of the jurisdictional challenge and sent it back to the pretrial chamber for consideration. But basically, we're in a position where the warrants are hanging in the air, doing their real work, which is to intimidate, harass, subvert the understanding of good and evil, undermine the very definition of statehood, and move considerations of foreign policy, war, peace, and identity from the local level to the international. This is a political threat, and it's a cultural threat to the free states of the world, of which, in my opinion, I apologize, America is the greatest, okay? And it must be dealt with swiftly, this threat, by those with moral courage and political strength.
Thank you very much. Those were all 3 really interesting presentations, and I've certainly got some questions that I'm interested in, but since we're getting toward the end, I want to make sure to give members of the audience a chance to ask questions. We've got some microphones in the back. If you'd like to raise your hand, then we can get you a microphone so that everyone can hear. Looks like our first gentleman was over here.
G'day. Mitch Firefield. I'm the president of the Law and Liberty Society of Australia. But more importantly, I'm a former ambassador of Australia to the United Nations. So I kind of feel like this panel was just put together just for me today. But just a few quick observations. Thibault, I have no issue with your analysis. I don't fault it when it comes to the International Court of Justice. Just one observation I make, and I think this might be part of the problem of the ICJ, is the way that the members of the court are appointed or elected. They're elected by the full membership of the UN General Assembly, which is good, but member states have to nominate someone for that election. And you might expect that it would be the executive government of a member state who would make that nomination. But that's not actually how it works. There's a panel in each country, which usually consists of the Chief Justice of the Superior Court, a Solicitor General, and another judicial officer. They, by convention, make a recommendation. Well, they don't make a recommendation. They submit a name to the executive government of the country, and that government feels duty-bound to then nominate that person. So I think that's part of the problem, is you're not actually having candidates nominated by executive government, but instead by jurists. It's echoes of the way that judges are appointed in Israel. So I think that's a particular issue there. And Aylana, thank you for your presentation. In Australia, one of the most fiercely debated topics in Parliament, and previous incarnation I was in our national Parliament, was whether Australia should sign up to the Rome Statute and the International Criminal Court. Our then Foreign Minister, Alexander Downer, prevailed, convinced people that it was a good thing to do. But you'll be pleased to know that today he says it was the greatest mistake of his time as Foreign Minister. He's recanted and he regrets it precisely because of how Israel is treated. So anyway, some people learn from their mistakes. And finally, Jose, thank you for your analysis. I think that's a good example of problems that are created by member states who cede their authority. The UN General Assembly ultimately is the member states assembled. It had 50% plus one to do things, 50% plus one to stop things. It's essentially a parliament. And most of the problems with the UN arise from the fact that member states are not taking control and not saying, this is our organisation and we're in charge of it. And just a final observation, you made a very good point about subnational entities, state governments, provincial governments, local governments, entering international agreements. Well, we've found a solution to that in Australia because, you're right, that undermines national sovereignty. According to the Australian Constitution, the federal government has responsibility for foreign affairs. So what we did was we passed legislation to actually give that meaning so that our federal government can kill any agreement that a local, state, provincial government enters into with any foreign entity. So that's just something practical that member states can do. Thanks.
Thank you.
Thank you.
Any questions from around the room? A few at this table. And we've only got a few minutes left, so I'll ask everyone to be
just a very
brief in your question.
Quick question. Given what we have discussed about the ICJ, the ICC, are these institutions of global governance actually capable of being reformed, or should we instead be going back to our home countries and advocating withdrawal? And I might share later an anecdote about the ICJ and one of our former High Court judges, but I'll save that for the panel later. But the question, I suppose, should we withdraw?
Any views on that? First, you, I suppose.
Could I just add to that quickly? My name's Tristan Hayman from the Law Liberty Circle, and very helpfully Xavier had my question, so I'm very glad that we've both asked it. But I just wanted to mention that in the UK, both significant right and centre parties, they've announced that their policy is now to leave the European Convention on Human Rights. So in the UK, the direction of travel is definitely toward exiting these organisations. And Thibault, on that Swiss climate change case you mentioned, the UK judge was the only one who dissented, and actually that was a really important reason why the UK's Conservative parties just decided to leave, because they've decided that the ECHR is unreformable on that basis.
Well, thank you. That's certainly one answer. Let's get some from up here.
That's the ECHR is a good example because the UK hasn't withdrawn yet, but since they are putting a lot of political pressure on the court, we see a tendency where the UK is less condemned by the court than the other countries, because the judges think that they might get the UK more angry than they are already. So maybe we could withdraw, but if we put political pressure on those courts, we can also win the political battlefield. So this is my point of view on this.
Thank you. How about you?
Well, I mean, I'm going to caveat this by saying I'm not an expert, and there are experts in this room that you should definitely ask for a more well-formed answer. But I think there's a distinction between, let's say, an institution like the ICJ, which does deal with, it's not all law of armed conflict in the most heated political debates that we have. Sometimes it really gives advisory opinions that are relevant and good and professional on all sorts of other relations between countries. And if one wants to talk about, should we just withdraw and walk away, then there's a bigger question about how global governance is really supposed to work at all, if it is. And I think it's a legitimate question to entertain. The ICC, however, in my humble opinion, and not speaking for the forum, which takes no official positions, would be best if it were gone. Like, I'm not exactly sure what value it's added. I think people should withdraw. I think countries should withdraw if they value their own freedom and their own sense of morality, because it really is, as Thibault was talking about, politics in the guise of law, that particular institution. And I think that when you play along with the perversion of the rule of law and of the truth, it ends up distorting and hurting you as well.
Any thoughts, Jose, or should we move to the next?
So I would say that it ultimately depends on what kind of international organization you're talking about. So even the UN, we talk about the UN system. So rather than be an organization, the UN is a network of organizations. I would say, as a general rule, if your country, and usually it's OECD, developed countries that fund those organizations, if your countries are funding those organizations and those organizations are working against your own interests, I don't see any reason why you should keep providing funding for those organizations, So in that instance, I think that, for example, the current administration did the right thing in pulling the US out of UNESCO and in rejecting also the Sustainable Development Goals. And I would say that more importantly, we should be very mindful of the kind of language that we use. We usually talk about cultural wars, right? Cultural war is ultimately about language. So without realizing, we start using words such as sustainable development. And then you investigate the genealogy of that concept, and then you go back to a 1987 report commissioned by the United Nations. You start talking about reproductive rights, which is just a euphemism for abortion, euthanasia, and assisted suicide. So I tend to be in favor of withdrawing for those organizations, but again, you have to be selective. You have to know what organization you're talking about, what the position of your country, but more importantly, be mindful of the language that you use, because it makes no sense for your country to pull out of an organization but keep using the same language, and then without realizing, this language is shaping the very conceptual framework of what we have of reality.
Thank you. We'll take one more fast question from this side of the room since I've neglected it.
Thank you for each of you appearing. I got to go closer to it. Thank you. Okay. For each of the topics that was discussed, I wonder what the balance is as far as the efforts from, we'll take the ICC, ICJ, Palestinian statehood, transnational progressivism. How is democracy and sovereignty doing in that struggle? Is it very much uphill? Is it balanced right now? I wonder if the panelists could discuss that.
That's a great question. About 20 seconds each.
I got to go first on that one. Great. Look, Israel, I think, is I can say a lot of things about our judicial system and our balance of powers and the malformations that we currently are trying to work with and reform. However, as a nation state which understands its purpose and its identity, I think it is the leader in the world, and that these challenges from the outside only strengthen it for the most part. There is a domestic impact within the country to these international organizations, which is because, and this hooks into what Mitch was talking about, because there's sort of this legal political complex that within the country that believes that only it knows how to talk to these global governance organizations. And so what the global governance organizations say becomes a chip within the country to strengthen domestic legal authorities in their battles against the electoral politics. And there I would say that there's, I think, a democratic problem. But it's a much, much larger issue. And if I could steal just 5 more seconds, I would say that the best guy to talk about it is in the room right now. He's plugging a book here at the conference, Yonatan Green. And it's on the Israeli legal system, and you should definitely check it out.
Thank you. Any quick thoughts from our other panelists, or are we ready to adjourn? Well, let's give our panelists one more round of applause. I also have the honor, I feel like I'm at the Oscars. I have an envelope that I've been told to open at this time. A very special announcement. Best Actress goes to... At 1:30 p.m., Justice Amy Coney Barrett will be signing copies of her new book, Listening to the Law. Copies will be for sale on the concourse level outside the cabinet room where the signing will occur, and the signing will conclude at approximately 3 p.m. So for all fans of Justice Barrett and her wonderful new book, please take advantage of that opportunity. And thank you all for your attention during this wonderful panel.